In many circumstances, a court will find the defendant's contacts with a state will amount to, are sufficient for there to be specific jurisdiction, even where it appears under the facts that actually there isn't much specific focus on that jurisdiction. For example, and again, the cases are not necessarily consistent and they differ state by state, but there are instances where jurisdiction was found where, for example, the defendant supplied promotional materials that were actually tailored and drafted with respect to the residents of that forum. For example, New York, if you tailored sales literature or promotional materials directed to New York businesses and individuals, sending employees or agents to the forum to provide training or sales activities and things like that. I mean, there are no rules about how many employees can you send, how often can you dare send them before a court will decide that it has jurisdiction. There just simply isn't any black letter rule. A distribution system in the forum, distribution licenses, these are the kinds of factors that courts look at. The contacts with the forum by a foreign company's employees and its agents are generally deemed to be the contacts and activities of the employer. They are attributed to the employer for the purpose of deciding whether the employer, whether the forum entity has availed itself of the privilege of doing business in the forum sufficient that a court can find it's consistent with due process for the defendant to be required to defend a case there. However, in general, the presence of independent contractors, parties who are not employees or agents, but are independent contractors, is generally thought not to be enough to be a basis for a finding of specific jurisdiction. In general, the contacts of a subsidiary or a related company with the forum do not automatically establish jurisdiction. Of course, many foreign companies will set up a U.S. domestic subsidiary organized in Delaware or California or some other state. The presence of that U.S. subsidiary, as a general matter, will not give jurisdiction over the parent company. But oftentimes, courts will look into the issue about whether the subsidiary really has been, in fact, treated as a separate entity, whether the corporate formalities have been maintained, whether its corporate documents are current, whether there are the procedure formalities required under the law of the corporation, for example, annual shareholders meetings, a board of directors meetings, minute books, things like that. If the court finds that, in fact, those corporate formalities at the subsidiary level have not been observed, the court may say, well, the subsidiary is really not a separate legal entity, that the subsidiary is actually the so-called alter ego of the parent. And on that basis, the U.S. court may exercise jurisdiction over the parent. Another theory that plaintiffs often pursue is that the subsidiary is actually acting as the agent of the parent company. In other words, that the subsidiary's activities are really so completely controlled and are not separate from those of the parent, so that the court can conclude that actually the parent is present in the forum and subject to jurisdiction because it is there in its subsidiary, its agent, that its agent there is present. These issues are all, as I said earlier, an objection to personal jurisdiction has to be raised right at the outset of the case. And if such an objection is made by the defendant, what you will then have is kind of a mini proceeding, an abbreviated proceeding, just on the issue of whether there is jurisdiction, whether the defendant has sufficient contacts or is present in the forum. And usually there's discovery on this issue. The court will stop the case from going forward until personal jurisdiction is resolved, and there can be the plaintiff can take document discovery and depositions to find out what the scope of the defendant's activities are in the forum. As I said earlier, specific jurisdiction means that the jurisdiction is restricted to causes of action arising out of or relating to the foreign or non-resident's activities. And the plaintiff's claim must relate to those activities in the forum. For example, a plaintiff that is injured by a non-resident defendant outside the U.S. Say someone is traveling outside the U.S. and there's an accident and they're injured by a non-resident defendant outside the U.S., cannot establish specific jurisdiction in the U.S. relating to that, even if the defendant has unrelated contacts with the proposed forum. The claim, if it's specific jurisdiction, the claim must be related to the defendant's activities in the forum. This year, interestingly, the United States Supreme Court has issued 2 decisions on the scope of personal jurisdiction from the standpoint of the U.S. Constitution and due process requirements. The U.S. Supreme Court doesn't often speak to these issues, so it's kind of interesting this year that there have been 2 decisions. One is this McIntyre decision, in which the Supreme Court rejected the assertion of specific jurisdiction over a British manufacturer of a machine that was sold through a U.S. distributor and ended up in New Jersey and injured a person in New Jersey. The New Jersey court had concluded that it did have jurisdiction, and the plaintiff in that case had relied on the fact that there was a distribution agreement to sell the products in the U.S., that the defendant's employees, the British company's employees, had attended trade shows, had come over to the U.S. to attend trade shows, but importantly, they had not attended them in New Jersey. And 4 of the defendant's machines had ended up in New Jersey. So that, for the New Jersey court, was sufficient to exercise jurisdiction over the British company. That ended up going all the way to the United States Supreme Court, and the Supreme Court said no, that's not sufficient. That would be a violation of the United States Constitution, that just placing products in the stream of commerce, knowing and expecting that they'd be purchased ultimately by consumers in New Jersey and elsewhere, is not enough to establish jurisdiction. It's not enough to show that the defendant had purposely availed itself of the New Jersey market. I think in that case it was significant, and frankly, sometimes you can see the facts of these cases, and they seem to be result-oriented, driven by the facts of the case. Here you have a sympathetic, I don't know what the specific injuries were, you have a plaintiff who was injured in New Jersey making a claim, and I think the court kind of reached to hold that it had jurisdiction over the defendant so that there would be a responsible party that the plaintiff could pursue its claim against. So sometimes, as I said, these things tend to be extremely fact-driven. The third type of jurisdiction is general jurisdiction, and by that we mean that the court not only has jurisdiction to hear claims relating to or arising out of the defendant's activities in the forum or its connections with the forum, but has plenary, full jurisdiction to hear and decide any claim on any subject matter. And this is a much higher standard. The court, for it to be constitutional for a defendant, for a court to exercise general jurisdiction, its activities must be continuous, ongoing, systematic in the state. Here is an example where a manufacturer, this is the Metropolitan Life case, a manufacturer sold over 4 million products in the forum state, It contracted with so-called authorized local businesses. In other words, it was selecting the local businesses and presumably exercising some control over them. It provided support and training to the local dealers. It engaged in national advertising that reached the forum. Very importantly, the foreign company had registered to do business in the forum, and it had sent sales employees to the state on numerous occasions. What the court said is you add all those things up, all those contacts, this is continuous, regular activity. The court concluded, for all intents and purposes, this defendant is here and subject to general jurisdiction. Another example with it was one where there was a store whose only contacts with the forum state were that it derived 3.2% of its income from sales to local residents and maintained an interactive website. Most businesses do that these days, potentially accessible to 2.2 million state residents. In that case also, that's in Texas, the court found there was jurisdiction. You see, all of these are very fact-intensive, and it's not always possible to harmonize the results. Just by contrast, that last case cited here, the helicopteros case, the court found that merely purchasing as opposed to selling goods and services in the forum state, even if you did it at regular intervals, is not by itself enough to subject a non-resident to general jurisdiction. And I think that's generally recognized by courts that if the activities are you're purchasing, it's much less likely that the court is going to find that there is jurisdiction than when you're actually selling products into the forum. The second case relating to jurisdiction that the U.S. Supreme Court decided this year related to this topic, general jurisdiction. It was Goodyear Dunlop Tires operations, decided in June of this year. And there the court again rejected a state court's assertion of general jurisdiction over subsidiaries of a U.S. company premised on the subsidiary's placement of products into the stream of commerce. The facts of the case were, again, this is kind of a sympathetic fact situation where I think the lower court, the trial court, had kind of stretched to bring the defendant into the forum so that there would be a party that a sympathetic plaintiff could pursue a claim against. Here, these were parents of children who were killed in a bus accident in Paris, France, and they sued the tire manufacturer's European subsidiaries, trying to pull the European subsidiaries into a North Carolina court. And the North Carolina state court said that's sufficient, that Goodyear Dunlop Tires, European subsidiaries, apparently they're the ones that made the tires that were on the bus that caused these deaths. The trial court found jurisdiction. The U.S. Supreme Court reversed and said that because the accident occurred abroad, outside the United States, the plaintiffs could not assert personal jurisdiction, that the defendants had no offices in North Carolina, they didn't advertise in the state, they didn't solicit business in the state, they didn't ship products into the state. So the court in that case rejected the idea that there could be jurisdiction over the foreign subsidiaries. The analysis is really the same. Just to repeat, the analysis is the same for from the standpoint, say, of a California court. A New York corporation is a foreign corporation, just like a Japanese corporation is a foreign corporation. In both cases, this analysis has to be done to see whether it's permissible under the Constitution for the California court to exercise jurisdiction.